Okay, so thanks to all of you for coming out on a absolutely, well, actually kind of a yucky day today. Today was kind of a rainy day here in Southern Connecticut. This is probably one of the few rainy days we've had in a while, but thank you for braving the elements and coming out, for some of you, in the middle of your summer vacation. At least that's how I see most of you dressed, and this is probably the way you dressed anyway for everyday life, but we won't say anything about that. But I want to give, first of all, give yourselves a little bit of an applause. Just not for me, I haven't done anything yet, but give yourselves a little applause. Because you have chosen to take an evening out of your summer plans to spend the next hour listening to a lawyer talk about how to market yourself and your business better on social media. Does it get any better than that? Okay, kill me now. I can hear some of you right off the bat. But this is really an important topic, and it's a topic you're going to be hearing about a lot in the next few years. There's no question about it. Social media has taken over our lives in a very, very big way. How many of you here have a Facebook page? Show of hands. Okay. How many of you here have a Twitter account, a hashtag? Same hands. How many of you here have a Pinterest account? Okay. How many of you are doing things on Snapchat? How many of you are doing things on LinkedIn? Pretty much the entire room. How many of you are doing things on Periscope? Ah, that one you haven't heard about. That's the latest one. That's just came out. That is a mobile phone app. It's called Periscope, like a submarine periscope. And basically with this app, what you can do is you can take live video of anything that's going on in the world around you, save it, and upload it to all your social media pages just from the one app, from your smartphone. This is the app you want to have if you're in the middle of a crowd and you see a crime going down or something like that. That's the thing you want to do. Or if you're at a political speech and the politician's pants drops down, that's what you want to have in your smartphone at that point. It's the latest way. I call it a blessing for copyright lawyers, is what I call it, basically, because it enables people to steal lots of stuff and you can become your own James Bond. Those of us who are old enough to remember the James Bond movies with Sean Connery, remember he had these things where he could take videos of people like in his pen and stuff like that. This is the world we're entering into now. It's very much reality in this age. Okay, if any of you doubted that I was a lawyer, here's my first slide. This is the disclaimers. We always tell you what we're not going to do before we tell you what we're going to do. First of all, I am not an employee of SCORE. They bring me in from the outside. I am a total independent contractor. So if you listen to anything I say tonight and it really sounds good and you implement it in your business plan and it doesn't work out and you end up, your business fails, you end up filing for bankruptcy, your spouse leaves you, your dog pees on your leg, and your kids don't want to know you anymore, you file for bankruptcy. It's not my fault. It's not their fault. You cannot sue SCORE, and it's not my fault either because I'm a lawyer and you really can't sue me. So forget about that. The second thing is, and this is really the more important thing, is that while we are going to be talking about some legal and tax stuff in this presentation, I'm really not in a position to give any of you one-on-one advice because I don't know any of you. For me to get to tell you what you should do, I would have to sit down with you for a while, spend some time, and figure out what you're all about. And I don't really have the time to do that tonight. So while the information that I'm giving you is good information, it's no substitute for legal advice, for which you really should get a lawyer or a tax advisor or an accountant to help you with. So those are my little disclaimers. Let's get started with the basics. What is social media? For some of you older folks, we used to refer to this as Web 2.0. You'll see some older articles referring to it as that. Basically, it's a category of websites that is based on user participation and user-generated content. Initially, in the early 1990s, when the internet first came to public awareness, websites were one-dimensional. They were one direction. If you look at my website at cliffeneco.com, which is the website for my law practice, there's no interactivity there. I'm just talking to you. I'm giving you information which you can read and you can take it or leave it as you see fit. That is Web 1.0. Web 2.0 makes it interactive. On a social media website or a Web 2.0 website, I am talking to somebody and they are talking back to me. That is the big difference between a regular website and a social media website. Or as one of my clients calls it, the illegitimate stepchild of a website and a blog which incorporate the worst elements of each. That's what he calls it. And he didn't use the word illegitimate. The key is that the site is interactive and sometimes public. Here are some examples. You all know them. LinkedIn, commonly used for business networking. This is primarily a B2B social media site. Facebook and MySpace, which are more B2C type websites for family and friends. I have a family that's very dispersed around the country. No state has more than one Eneco, just about, and there's about 50 of us. So Facebook is kind of a godsend for us because we can actually create a Facebook page where we can talk about what everybody else is doing without having to incur a lot of long distance telephone bills. We're the people, we're actually referred to as a Facebook family. You know, people that communicate with each other solely on Facebook, which some people think is a better way than the more traditional way of interacting at Thanksgiving dinner or something like that. Twitter, obviously, Twitter is a micro-blogging site. You post tweets of up to 140 characters that basically answer, what are you doing right now? The idea of Twitter is to create a sense of what the zeitgeist is at any given moment in time. What's going on in the world at exactly this moment? YouTube is a place where you can post videos. I have a YouTube channel. If you go to YouTube and search for Cliff Eneco, you'll see all the videos I have up there. Instagram, which is an online bulletin board for photographs and graphic images, as is Pinterest. Snapchat, photo video sharing site. The thing about Snapchat is that posts are supposed to disappear between 1 and 10 seconds. Kind of like, remember Mission Impossible? You know, when what's his name, Mr. Phelps, gets his marching orders and then the tape, you know, self-destructs within 10 seconds. That's kind of what Snapchat is all about. I personally question, though, whether Snapchat really deletes the stuff that's up there. I kind of have a question about that. I'm not a Snapchat user, but I kind of have a question about that. You know, I really am a subscriber to the belief that everything that you do on the internet is permanent. And I really don't believe that anything can ever be permanently deleted. Even though people, the general public can't see it, there are other people with specialized equipment who can. Okay? Social media is becoming all pervasive. Here's some interesting statistics. More than 1 in 3 Americans have Facebook pages, and the vast majority of them under 50, I would say 99.99% have a Facebook page. Facebook is the largest country in the world. 1.44 billion monthly active users. China only has 1.36 billion people. They have to do some catching up there. Twitter has roughly 236 million monthly active users, although that number is kind of fluctuating right now. If you read the business newspapers, Twitter's having some difficulty growing beyond its current subscriber base. There's some question about the management there. MySpace, how many people here still have a MySpace page? I'm just curious. You know, back in the early 2000s, this was the social media site of all social media sites. And a lot of people have written it off as a thing of the past, kind of like Yahoo or somebody like that. But I think that that's a mistake. MySpace still has roughly 50.6 million users, and a lot of those in the entertainment business. If any of you have a grandson or a son or a daughter who's got a rock band, I'm sure that they have a MySpace page. They probably have a Facebook page as well, but they definitely have a presence on MySpace. MySpace tends to lean very heavily to the entertainment community worldwide. And virtually every American between the ages of 10 and 25 is social media active. If you have a teenager in your house, right, here's a picture of your teenager without the bald spot. That is your teenager, head down, slumped over, doing something on social media. No secret, these kids live for social media. That's what they grew up with. Okay, a couple of things and social media is really changing our society in a very big way. I mean, the internet really dramatically changed our society back in the 90s and early 2000s, but social media has really taken things to a much level. Our lives are a lot more public. A very dear friend of mine just posted something on his Facebook page this morning. He and his wife are vacationing in Cape Cod, and they went to this restaurant, and they actually took a photo of the dessert that they had for dinner last night. How many people here have friends who do this all the time? Okay, of those of you who do you really care about the dessert? You know, but the picture of that dessert is preserved for forever. If you think of archaeologists digging through this stuff 3,000 years ago are going to find a picture of that dessert, and they're going to think that that's what we all ate back then, you know, back in the day. You know, it's amazing how things are misinterpreted when you look at stuff like that. We're also being untethered to a specific physical space, but we are tethered to our technology. It used to be that we were the slaves of location. Where you were said a lot about who you were, what you were doing, what your business was all about. When you go to law school, the very first class you take is a class called Civil Procedure, specifically how to try a legal case. The first thing you learn about is jurisdiction. You know, where does the court have authority to act? Everything in law is based on jurisdiction, on where things are, on boundaries, federal, state, local boundaries. That dictates a lot of what the laws are. On social media, boundaries are meaningless. They are. We are no longer tethered to a physical space, but we are being tethered to our technology. How many people here start to feel a little weird when you don't have your cell phone in your hand for like 5 minutes? Okay, there's quite a few people, and not all just the young ones either. You know, we're feeling a little guilty when we leave it go for a little while. We're starting to develop personal brands that must be maintained. One of my favorite authors, by the way, and unfortunately he passed away about 10 years ago, was a gentleman named Neil Postman. He was a professor of sociology at one of the New York City universities. I think it was NYU, but I'm not 100% sure. He wrote a bunch of books in the 1980s and 90s that were very prescient about forecasting how technology was going to affect our lives. His greatest hit was a book, some of you may remember, called Amusing Ourselves to Death, about how everything is becoming entertainment, how politics is becoming entertainment, how news, journalism is becoming, everything is devolving into entertainment. And that book, all you had to do was watch the debates last week, folks, to realize just how right Neil Postman was, 30 years ago, predicting how all this was going to happen. Well, my favorite book of his is a book called Life, the Movie, about how technology, because technology is enabling us to broadcast our lives to the entire world, a lot of us are starting to become actors in our own lives. We're developing a character, a persona, who in some cases is quite different than our real world. This is one of the books, if you're truly interested in social media, this is one of several books I would recommend. Another great book, by the way, which I would recommend, is a book called The Circle. Has anybody here read it? It's a novel. It's by Dave, I can't remember his last name, but he's a famous novelist. He's written a lot of novels, mostly about social conditions and stuff like that. He wrote a great novel called David Eggers, E-G-G-E-R-S. He wrote the book Zaytoon about Hurricane Katrina and New Orleans and all. Really a very great social commentator. And he wrote a book last year called The Circle about this young woman fresh out of college who goes to work for a company that's kind of a combination of Facebook and Google. They have come up with a social media solution where you basically create this page and that page becomes you. Everything that you do must be uploaded to that page. Very interesting about and how people are penalized if they don't stay active online for periods of time. It's actually, some people have called it a 1984 for the digital age. It's a book you should be familiar with. You have to read one novel in what remains of your summer vacation. The Circle is a book, just came out in paperback, by the way, so it's relatively cheap. Get yourself a copy. It'll really open your eyes to how social media is changing the way we look at the world. We all believe we have something to say or share, but are our lives truly unique? Let me ask you folks, show me a teenager in an upscale suburb of New York, and I will show you a teenager in an upscale suburb of any community in the United States or Canada. There is not a whole lot going on different between these folks. If you're a teenager in your sophomore year of high school, your experiences are roughly the same as high school sophomores just about everywhere else in the civilized world. Do you really have that much unique to say about your life, your experience? But unfortunately, we think we do. We also believe, and this is affecting our politics in a big way, that the crowd knows more than we do. How many of you have bought a book on Amazon.com or some other media on Amazon.com because you liked the user reviews? You read the reviews, there were 10,000 positive reviews that were 5, another 15,000 were 4, another 10,000 were 3. We've all done that, haven't we? Do you realize, by the way, that most of these reviews are posted by people who work for the publishing companies? Do you know that? That a lot of these people are not just real, or they're professional bloggers who do this kind of thing. These aren't just random people who are talking about the book, at least in most cases. In some cases they are, but in a lot of cases, I can tell you some stories about this. But when we see stuff like that, we tend to think, well, how bad can the book be if 10,000 people have given it a 5 rating on Amazon? We all tend to fall victim to that. And then last but not least, social media currency is reputation and perceived expertise, not experience, title, or affiliation. This has been called the death of experts by one author. I have been asked, when I pitch for speaking gigs, I frequently am asked, how many Twitter followers do you have? How many Facebook friends do you have? They care about that kind of stuff. Never mind that I've been doing this for 35 years. And I have several degrees and I've written 10 books on the subject. Never mind that some high school kid can go on and talk about the same thing that I'm talking about now, and he will build a following, or she will build a following on Facebook with everything that they do not know. So these are all ways in which social media is impacting our society. Let's start talking now about the legal side of things, because that's really what SCORE asked me to talk about tonight. Okay, I want to talk about the social media sites themselves first of all. How do social media sites get into legal trouble? Believe it or not, all of the major social media sites that I just listed on that other slide have all been sued at least once by the Federal Trade Commission. Some of you know the Federal Trade Commission in Washington, the FTC, that's the government agency that administers, among other things, the advertising laws, what you can and cannot say in your advertising. Every year or every other year, the FTC has brought enforcement actions against Google, LinkedIn, Facebook, Twitter, every one of the majors, because they're doing things that violate their privacy practices. It's amazing. And what happens is, you don't hear about these a lot unless you read the business trade newspapers. What happens is that the big sites, they settle these things, and then the very next year they get sued again for something else. It's like a yearly ritual that they go through with these things. So how do these sites get into trouble? Well, most give away their services free to users. Now, we love the fact that social media is free. I mean, Mark Zuckerberg, the founder of Facebook, has gone on record as saying he will never ever charge for a Facebook page. Okay, and we love that. You know, you can do anything you want to do on Facebook. The space is almost unlimited unless you put up a lot of videos. You know, we can do whatever we want and it doesn't cost us a penny. But looking at it from a business point of view, that creates problems for Facebook, for Twitter, and all these companies, because that leaves them only two sources of revenue. If you think about it, advertising, right? How many of you are seeing ads on your Facebook page that you really don't know about and you don't care about? And in some cases, in my case, I'm seeing ads on my Facebook page from competing lawyers and law firms, which I really don't like, you know, but they're paying for that and I'm not. So that's why Facebook's kind of giving them a little prominence. And of course, if I write them a nasty letter, they take it down, but 2 days later, kind of comes back, you know. It happens. So advertising obviously is a big source of revenue, but also sales of user data to marketing research companies. Do not fool yourself. When you do something on social media, data is being captured, and that data is being sold. Whatever they tell you, it is being sold. And why is it being sold? Because that's one of the only ways that social media websites can make money. There are people out there. Cliff Enico had a bagel for breakfast this morning. It's not very valuable information. Cliff Enico had a Thomas's English bagel this morning. Is extremely valuable information. And there are research companies that will pay a ton of money to find out what my brand preferences are, what my hobbies are, things that I look for. That information, and hopefully it's not personally identifiable to you. It's what we call statistical aggregate information. But there's nothing to prohibit social media sites from buying and selling and trading in that information. And believe me, they all do it. I don't care who they are. Relying on data sales for revenue means that social media companies cannot guarantee privacy. A couple of years ago, in 2013, Facebook did something interesting in response to one of those FTC enforcement actions that I was talking about. What they did, they made a few changes to their privacy policy, which the FTC required, but they also changed the name of their policy. They don't call it a privacy policy anymore. If you go online, they call it a data use policy. Now, maybe I'm a lawyer, of course, so I live with language and subtle language changes and stuff like that, but I think that that's a very profound change from saying, here's how we're going to keep your stuff private, to here's how we're going to use it. We're going to use your information, but here's how we're going to use it. That, to me, is a very, very significant change in emphasis. Virtually every social media site has been the subject of an FTC enforcement action, and this will continue. The big fight of the next decade is going to be over privacy on the internet and security. That is the battle royal that is going to be fought online in the next 10 years. That's where all the internet cases are going to be. Okay, so now let's talk about, that's how the sites themselves get into trouble. Now, how do the users, how do you get into legal trouble? There's a bunch of ways you can do it. You can freely copy what you see on a social media website, and you can get sued for copyright infringement, taking somebody's stuff without permission and using it without permission. You can post inappropriate or offensive content and get sued for hate speech, very common on the web. You can badmouth people on your social media pages and get sued for libel or possibly lose your job. In fact, there's actually a word for this now. We call it being deuced. Losing your job because of something you said, stupid, about your employer on a social media site. There's actually a word for this. Someone who says something dumb about their employer, talks about trade secrets or about the suspicions that so-and-so and so-and-so are having an affair, that kind of stuff, and actually losing their jobs for it. That's called being deuced. It comes from the first person who was ever deuced at least that we know of. The first case that we're aware of was a young lady who worked for Hewlett-Packard. She was a junior marketing executive who got fired because she posted some stuff about her superiors that she shouldn't have done. And her online handle for her Facebook page was Deuce123. That's how the term deuce came about, in case you're curious, okay? Okay, so it's so common now that there's actually a word for it. Isn't that weird? We're going to talk about employers and employees a little bit later. Companies can refuse to hire someone after reviewing their social media pages and then get sued for discrimination because they saw things that violated the federal anti-discrimination laws. And then last but not least, you can post embarrassing content that can be used as evidence in a court of law. There was a big Supreme Court case back in June of this year, which we're going to talk about, the Elozio case. Okay, but let's have some fun first of all. Before we start talking about legal stuff, let's just show you, here's some, these are actual cases, by the way, from around the country that I pulled from one of my publications. I write a publication for lawyers called Advising E-Businesses. It's for lawyers mostly about how to advise, e-commerce startups mostly. And these are some of the cases I took from my own book. Joe, this is from California. Joe applied to the Social Security Administration for disability benefits. He said he was totally disabled because of a workplace accident. Right before his hearing with the government, he goes on his Facebook page and he posts up some pictures. His first picture shows him riding an all-terrain vehicle in the Mojave Desert. You ever see those things? They're like little Jeeps and stuff like that. And the second picture shows him hoisting his girlfriend up over his head. And I will tell you, the girlfriend was no 80-pounder, okay? Now, how do you think his hearing went for total disability? Not very good, okay? But unfortunately, there's some more serious cases. Lara, this is out of Indiana, received 2 years in prison after posting pictures on Facebook of herself drinking and partying just days after causing the death of her best friend in a drunken driving accident. They threw the book at her for that. A similar case, this one I think was Ohio. Josh received 2 years in prison for DUI. He was found guilty, but between his court hearing and his sentencing date came Halloween. And he went to a Halloween party during this time, awaiting sentencing for DUI, dressed in an orange jumpsuit with like a number across his. And the prosecutor actually used that as evidence that he should be handed down the maximum sentence under Ohio law, which as it happens was 2 years. The judge threw the book at him, not so much because of his crime, but because he was making fun of his own guilt. I'm not so sure how I feel about that from a First Amendment freedom of speech standpoint, but these are the kind of cases that are coming down for people. Okay? Here are some Twitter goofs. Those are some Facebook things. Here are some nice Twitter goofs. These are actual cases. Cisco Systems just offered me a job. Now I have to weigh the utility of a fat paycheck against a daily commute to San Jose and hating the work. I've been doing this program for eBay sellers around the country, and of course eBay is based in San Jose, so I always get a big laugh out of that. But this was actually Cisco Systems, not eBay. And obviously the employer, the hiring person, got a hold of that tweet, and that was the end of that. A public relations consultant landed a big deal with a big company out in the Midwest and said, boy, I would die if I had to live there. Not good. Courtney, the minute you see Courtney Love, okay, you know it's going to be good, okay? The widow of Kurt Cobain of Nirvana, right? Courtney Love was sued for libel after tweeting that her former fashion designer had a history of dealing cocaine, was guilty of assault and burglary, lost custody of her child, and was a nasty, lying hosebag thief. Okay, knowing Courtney Love, those was not her actual words, okay? Actually, the nasty lying hosebag thief, I don't think is libel, I'll be honest with you. But the rest of it almost certainly was, and I'll talk about that in a few minutes. Okay, so what's the law? Okay, one thing you have to know about the law, lawyers are not cutting edge. We're not. We're not ahead of the curve. We are actually about several steps, in fact, in this case, we're light years behind, frankly, trying to catch up. We're still trying to figure out websites. Quite frankly. We are very far behind the curve. The law always plays catch up with technology and with what people are doing. We don't really have a whole cases on social media. The oldest cases that I can find on social media date from 2007, 2008, which were only a few years ago. And they're mostly lower court cases. We only have a couple of federal appeals court or Supreme Court cases that cover the entire country. Most of these are local cases, so we are getting into situations where the law in some places is different than the law in others. You can't really generalize a lot. Right now we just have a bunch of social media cases, but there are some generalizations we can make from them. That's what we're going to talk about tonight. So let's talk about some specific issues. When you post something on social media, is it private? Do you have an expectation of privacy? The cases are unanimous so far. If you put a post on a public site or if you do a public tweet that is intended for the entire world, there is no expectation of privacy. If you're posting something on a public site, or if you're making a public tweet that is available to the entire world, the cases so far are unanimous that you do not have an expectation of privacy. Anybody can take that information and use that for whatever purpose they like. So be very careful when you're doing stuff on Facebook. Make sure that you deselect the public settings if you're going to be doing stuff that might potentially lead to legal trouble down the road. A posting may be private. The cases here are not unanimous, but a posting may be private if it is on a password protected site, or the site has high security settings that prevent outside users from viewing the site. So look at your encryption settings when you do your social media, because it could be very, very important how you do those. If you're deliberately limiting, so for example, that website that I talked about on Facebook about my family, you cannot get into that unless you are an Eneco family member. And we actually have a committee of 3 of us, believe it or not, who make decisions about whether someone is truly an Eneco or not, and deserves to be allowed admission to the inner sanctum. Because a lot of people, it's actually a pretty common Italian name, and a lot of people think they're related to us when they're really not. So we actually have this, it's a committee, believe it or not, of 3 old geeks deciding basically who's an Eneco and who isn't. It's kind of fun. This is the world that social media has created for us folks. But if you're on a password protected site, you have a much higher chance of being held to a court saying that you intended and had an expectation of privacy. Generally speaking, social media postings should be treated the same as emails or text messages. They can be used as evidence in a court of law, as you saw in some of our little case examples there. Who owns a social media posting? When you post something online, let's say your latest haiku poem or something like that, who owns it? Well, believe it or not, you own it. The original author owns the copyright of their social media posting. So if you go online and do a beautiful thing about what you had for lunch, that day, and the restaurant takes it and puts it on their Facebook page without your permission, they have committed copyright infringement. They have not gotten your consent to your review. Even though the review was of their restaurant, you can actually sue them for copyright infringement because they took your stuff without your permission. Okay? You are the author as long as it's original content, as long as you didn't take it from somebody else. If it was your original content, whether it's a poem or a description of what you had for lunch, you own the copyright to it, unless, and this is what you got to watch out for, the website, the social media website that you're on, has a policy that states that anything you post, they own the copyright. And guess what? Facebook has such a policy, Twitter has such a policy, Instagram has such a policy. I don't know about Pinterest. But virtually all the social media websites have a policy. It's called a copyright and permissions policy. Sometimes it's part of their terms of use. Sometimes it's a separate standalone document. But they have a policy saying that anything you post online, they own. And this is driving artists and photographers nuts, because they put stuff on their Facebook pages, and of course they're putting on their latest photograph, whatever. In theory, Facebook could take those photos and create, lithographs and serigraphs and all kinds of things without the artist's permission and get away with that because the artist assigned their copyright to Facebook by posting that photo. Now, that's not their intention. That's not what they're trying to do. What they're trying to say is, look, if we see that you did something really cool and we want to tell the whole world about it, we don't want to have to come back to you and get your permission. So if we want to create an anthology of the 15,000 best Facebook postings of all time and we want to include one of yours, we don't have to go back to 15,000 people and get their consent. That's why our policy is like that. And that's fine, except that the way the policy reads, literally, it would also apply to a situation where someone puts their artwork up on Facebook. So whenever I have artists or whatever, I tell them, don't put your artwork itself on Facebook. By all means, do a posting saying, hey, I've got a brand new portfolio. I got 12 new works exhibiting in a local gallery. To see them, click here and drive them to your website and have the photos there. Because then on your website, that's your rules, not Facebook's rules. By all means, promote your stuff on Facebook, but until Facebook clarifies its policy, which they probably will do this year. This is one of the things that the FTC is going after them for, I think. I think this year is, to clarify their policy, but until they do it, have your stuff on your policy and just promote it on Facebook using words, okay? If you hire an employee to promote your business to friends and customers on social media, what we call the work made for hire doctrine applies. Anything that your employees create, and by employees we're talking about W-2 people who are specifically employees, in the scope of their employment, you own. That's what the work for hire doctrine says. That does not, however, apply to postings made by independent contractors. I'm seeing a lot more social media people offering to, these are social media consultants, offering to do postings for their clients who don't have time to do social media. Look, social media is very time intensive, am I right? You got to spend at least a few minutes every day, or at least 3 or 4 times a day to be considered current. A lot of people do not have the time for that, so they're hiring social media consultants to create content for them. And sometimes it's based on other stuff that they've written, sometimes they just make it up out of thin air. Who owns those postings? The answer is, if it's an independent, if that social media consultant is an independent contractor, the consultant owns it, not the client. You know, so if a social media consultant creates all kinds of postings that's generating tons of traffic for you, they have the right to take all that stuff off and give it to one of their clients, unless you get them to assign their copyright over to you. So be careful about that. Especially those of you who are using other people to generate your social media content. It's becoming more and more common these days. Let's talk a little bit more about copyright and trademark infringement. You know, can you use something? Let's say, for example, you have a blog and someone puts something up on the blog and it turns out that that something is a ripoff of somebody else's content, okay? The general rule here is that the person who actually infringed is liable for copyright infringement, but the site itself is not liable unless it endorses a posting or solicits or induces illegal behavior. So if you have a contest on your website where you say, hey, send us, if you see something really great online and you think it's really cool, you know, post a copy of it here, you could be held accountable if people start using other people's stuff without getting the copyright. You could be held with what they call secondary copyright infringement. But it has to rise to that level here. Unless you have specifically encouraged people to violate the law, you probably will not be liable. The Digital Millennium Copyright Act of 1998, all the great internet statutes at the federal level come from the late 90s, you're going to find, and there hasn't been a whole lot since, provides a safe harbor for social media sites. The deal is here, whenever you do your website terms of service, you've got to have what they call the DMCA copyright notice. This is a notice that says, if you see anything on our site that you believe is copyright infringement, you must contact us at this email address and give us 10 days to take it down, okay? If we take it down during the time period, or if we contact the author and the author says that it's not infringement, we're not liable. There's actually prescribed language for that. It's boilerplate language. You can take this language off of any terms and conditions of use that you like. It's always the same language. The language is actually required by the DMCA. So in order to be not accountable for copyright infringement as a website, you must have that copyright notice somewhere in your site. Most people put it in your terms and conditions of use. If you have a separate copyright and permissions policy, which some websites have, that's where it belongs, okay? You have to have a takedown policy for copyright infringement. As long as, in other words, what we're saying here is, look, we can't monitor all the thousands of postings that are going on our site every day. If you tell us that something infringes a copyright, you know, and give us a chance to take it down, we're not liable. That's it, you know. And then, of course, if you call me frantically the next minute and say, hey, Cliff, I just got this DMCA notice, what do? I'm going to say, take the bloody thing down. Don't get into a fight. Just take the stupid thing down and go on with your life. You don't want to get caught up in that little private spat that those two people are having over there. On Twitter, trademark infringement is not really such a big issue online, but the one area where it does come up, you cannot use a username or hashtag that confuses people about your relationship to a trademark owner or dilutes the owner's brand. Believe it or not, I once had a client whose actual name was Bill Gates. His real name, you know. He got into all kinds of messes because he was a computer consultant and he did a lot of stuff online. Everybody thought, well, this is the guy from Microsoft. No, it's not. It's this other guy, you know, that whole kind of thing. And he had to go jump through all kinds of hoops and stuff like that. Be very careful when you choose a cute, you know, hashtag or something that makes you look as if you are somebody else. Okay, now that's copyright infringement. Now let's talk about libel and slander, saying bad things about people. This is different. You are liable for everything you say on social media, okay? Whatever you say, you are accountable. But libel is not everything. You have the right under the First Amendment to express your opinions online. So if you go online and say, Cliff's a lousy lawyer, I don't think he knows what he's talking about, well, I'm not going to like that. You know, the proper response to that, by the way, those of us from Brooklyn or the Bronx, is your mother. Okay, that's the proper response to that. Hasn't changed in 50 years. okay? I mean, you're entitled to your opinion. My recourse there is to call you privately and have a nice private chat saying, I'm a lawyer, I know where you live, yada, yada, you know, that kind of thing. You know, I got a cousin named Vito who really likes his work. That kind of thing, you know, but you really can't do, opinions are valid. You can always express your opinion online. But a statement of fact that is not correct and is designed to injure somebody's reputation, that is libel. Or slander, if you say it verbally. But on the internet, we're always talking about libel, because everything on the internet is written or photo or graphic in some form or another. So Cliff as a lousy lawyer is probably okay, but Cliff has been sued by malpractice 36 times in the last year, which I assure you is a false statement. I haven't been sued once in my entire career, thank God. May that continue. That statement has to be 100% true, or else you have libeled somebody. So for example, when Courtney Love said about her fashion designer that she was a lying hosebag thief, that's kind of her opinion, you know, to be honest with you. The thief part, well, maybe not. But all the other stuff, that she had lost custody of a child or something, all of which was false, by the way, that is libel. It's a statement of fact that is not true and is designed to injure somebody's reputation, okay? But what about other people saying nasty things about each other on your site? Here the law really comes to your aid. Section 230 of the Communications Decency Act of 1996 is a statute that everybody in this room should be familiar with if you're doing a lot of stuff on social media. What this says is that if someone commits libel on a website, they are liable for their statement, but the website is not liable at all, period, end of story, world without end, amen. It is an absolute 100% protection. It's not like copyright infringement. In copyright infringement, you got to go through the DMCA takedown thing. You got to have that procedure posted up. Here you don't have to put up a procedure. You are protected by Section 230. Now, it doesn't mean they won't try to sue you anyway, especially if the stuff is really nasty. As a best practice, if you find out that somebody is libeling other people on your website, you should take it down anyway, just to get out of the fight. But the law doesn't require that you do that. Section 230 is an absolute protection again for website owners against libel and slander. Okay, threatening behavior. Okay, we had a big case on this year. The Supreme Court in June handed down the Ilanis case. I love the facts of this case. I mean, I really wonder about our Supreme Court sometimes and our government officials. I really do. And this case is one of them. My jaw dropped, frankly, when I heard it. I was aware of this case. I've been seeing it coming up to the lower courts. This fellow basically, you know, his wife decided to leave him. She took the 5 children with him, you know, left in the middle of the night, that kind of thing. And he was understandably not happy about that state of affairs. And he considered himself sort of an amateur rapper. So he started putting stuff up on his I think it was his Facebook page in rap style rhymes about how much he wanted to kill his ex-wife and the judge in the divorce case. This came about right after Sandy Hook. He also said he was having nightmares about shooting up an elementary school class because hell hath no fury like a crazy man in a kindergarten class. That was actually one of his quotes online, and included photos of him. I guess his office had a Halloween party, and he was joking around with a coworker holding a fake knife to her throat, and he put up a posting saying, "Boy, I wish this was my wife." Right? How many of you here would be worried about being in the same room with this individual, okay? By the way, he lives in New Jersey. This case came out in New Jersey, I should tell you. So he's in the neighborhood here. But he did something very clever. He put disclaimers on all this stuff saying the content is fictitious, there's no resemblance to real persons. All I'm doing here, look, I went through a very, very nasty divorce. I'm just blowing off some steam here. This is my way of expressing myself. And art is all about pushing the limits, and I'm willing to suffer for my constitutional rights. He made a specific statement that I expect that this is constitutionally protected speech. Believe it or not, the Supreme Court, 8 out of 9 justices agreed with him. They basically said that what he did, now what they were doing here was they were construing a very specific statute, a federal criminal law that makes it a felony at the federal level to make a threat in a publication against another individual, a threat of physical harm. And the court said that what he was doing on its face was a threat, but because of his disclaimers, they said that he really was signaling that he really wasn't serious about pursuing the threat. that he was doing. There's actually a famous case that you read about in law school from the 1600s, believe it or not, about these two gallants who get into a fight at a pub or something over in England, and the one guy says to the other, "If I had my saber with me, I'd cut your head off." And the top court in England at that time in the 1600s basically said, the very fact that he said, "If I had my saber with me," signaled to the other person that there was no threat of immediate harm because the guy was admitting that he didn't have his sword with him. And they actually referred to that case in one of the footnotes in deciding this. They're saying that what this guy did was the same kind of thing. I don't know about that if I were you. The facts of this case are very interesting. All I can say is sleep tight, ladies and gentlemen. Our Supreme Court is looking out for us. Okay? And if you meet a guy named Ilanis on social media, defriend him. Okay? I'm sorry. Okay. Let's talk about selling stuff. I mean, I do a lot of this for eBay sellers and Amazon third-party sellers, so forgive a couple of slides on this. You can sell goods and services from your Facebook page now. They're trying to come up with a way to e-commerce enable these things now with shopping carts and stuff like that. So if you want, if someone sees something that they like on your Facebook page, they can buy it right then and there. I'm telling my clients right now not to do it right now. I much prefer that they have a link to their website and sell off of their website. And really, there's two reasons for that. Number one, when you sell stuff from your own website, you're not subject to any Facebook or Twitter policy at all. You are subject to your own policies. You set the rules on your website. And you can create whatever return policy, cancellation policy you want. If you're selling stuff on Facebook, you're subject to their policies about returns and all that kind of stuff, and you don't want that. Also, too, if you're selling creative works, you want to avoid Facebook's policy of owning all rights to the artworks. We talked about that earlier. But really, the common sense should tell you this, people. There's only one place in the entire internet where you can sell stuff and keep 100% of what you make, 100% of the profits. And that is the stuff that you sell from your own website. Whenever you sell anywhere else, eBay, Amazon, whatever, they take a huge chunk of your profits. The fees on eBay especially are pretty astronomical. And Facebook, I mean, sooner or later they're going to charge. You know they're going to charge for this service as well. So whenever possible, you want to sell stuff off your own website and drive traffic to there, because that is where you get to keep 100% of your profit. That's where all your highest margin stuff should be. Go to any eBay or Amazon seller, look at their merchandise, and then go to their website, and I guarantee you'll see better quality merchandise there. Higher margin merchandise, because that's where they know they can keep the lion's share of the profits. Everything else is a tool to drive traffic to the website. Okay. Let's talk about advertising. Your advertising on social media must be, if you are advertising products or services, your advertising must be truthful and not misleading. You must be prepared to back up all claims. Be very careful of reviews and third-party endorsements. In 2010, the Federal Trade Commission changed their policy on celebrity endorsements, which they've actually had for a very long time, but they brought it up into the internet age. They actually did a pretty good job. Whenever somebody endorses your product or a reviewer says great things about you, even if it's an Amazon review of your latest book, there's two rules here. You cannot say, the person endorsing cannot say they actually use the product if they actually don't. Okay? So if you're saying, if you're selling a pair of sneakers and you're saying that these sneakers, and LeBron James is saying, yeah, I wore those sneakers in thus and such a game, you really got to do some diligence and make sure he absolutely did that. Because if he didn't, you're making a false claim. And then you also have to disclose if the person making the review receives compensation of any kind. So let's say that one of you has written a book and you want me to write a cover blurb or something like that, or a blog posting saying how great your book is, and you give me something. Well, obviously, if you give me a review copy, that's not considered compensation. But let's say that you give me something, anything, in return for that. I'll give you 5 hours of consulting service, Cliff, if you say nice things about my book in your blog. That, believe it or not, violates the FTC policy against receiving compensation. You have to disclose it. If any blogger or reviewer or somebody saying nice things about you is getting compensation in return for that, that fact has to be, the FTC doesn't prohibit you from doing it, but you have to disclose it publicly and let people know. Promotional. Have you ever seen the ends of the quiz shows, by the way, the game shows, where one of the announcers says, certain people will receive things in exchange for promotional consideration? You ever hear the fast-talking guy at the end that says that? That's why they're doing it, is because of that FTC policy. Okay. Your tweets, by the way, one of the great unknowns is whether a public tweet is considered spam. We don't really have a very good answer to that in 2015. We hope to have some cases in the next year or two, but right now this is really all I can tell you. Whenever you're doing a public tweet, not just a tweet to your followers, which is self-contained, but a tweet to the world at large, you always have to give followers the chance to stop following you. You have to have some kind of an opt-out policy. Those of you who do email marketing know this is a fundamental thing. You always have to have an opt-out page, and the opt-out option must work. You can't have an opt-out where people click, it goes to a dead page. You cannot send tweets to people. You cannot send a focus tweet. So for example, I cannot send a focus tweet to any of you specifically here. If you were to give me all your Twitter hashtags, I could not send a thing directly to you saying, hey, what a great program. By the way, I'd love to be your lawyer, hire me. Okay, that would be considered spam. Okay, if I did that. If I just do a tweet to the world saying, I'm the world's greatest small business lawyer, I just gave this talk in Darien, the people were just terrific, and yada, yada, that's okay. But if it's a focused tweet to somebody I don't know, that's considered spam. Okay, so only send focused tweets to your followers, to people who have specifically signed up to follow you. That's the bottom line. That may be more conservative than it needs to be, but in the absence of cases, I can't really give you anything more specific on that. I mean, technically, if you follow the rules under the 2003 CAN-SPAM Act, you're supposed to put a physical mailing address in all your tweets where people can, how can you do that with 140 characters? You can't do that. So that's so that's why I'm saying we are awaiting cases, because some of the stuff in the CAN-SPAM Act just doesn't make it in the world of Twitter. Okay, now let's talk about employees for just a few minutes here. Some of you probably don't have issues here, but this is where a lot of the case law has been in the area of social media. People who've been induced and then sued for wrongful termination. Can employers look at social media pages to make hiring decisions? Yes, but they do so at their peril. I actually had this situation about a year ago. A gentleman called me who was opening, he was the head of a local branch office of a major international firm. And he was looking to hire a manager for the local office. And for some reason, they weren't doing in-person interviews for this position. All the interviews were taking place online and via social media. This is a firm that wanted to be seen as being technologically forward. All right? So what happened was the branch manager came down to two candidates that he really, really liked. One was a male, one was a female. And he really couldn't decide between them. So what he did was, in his infinite wisdom, he did not call his lawyer first. Okay? He went online and looked at their Facebook pages. So he looks at the Facebook page of the female first, and of course the person there has a wonderful announcement congratulating me. I just learned, I visited my doctor today, I just learned I'm pregnant. Number one. So he figures, okay, that's bad. He then goes and looks at the male candidate's Facebook page, and he also had a great announcement that he had just become engaged to his significant other, his boyfriend. He's gay. That's when this gentleman called me and asked me for advice. Little too late, I think, for this. Basically, what I told him to do is to terminate the entire hiring process and begin from scratch again, is what I had to do. Either way he went, he was opening himself up to a potential lawsuit for discrimination. You can see how easily that can happen. This happens in the real world. I tell my clients, whenever you're looking at candidates for employment, do not look at their social media, ever. And because they can find out, I mean, they can track it. There's ways that they can find out if somebody from a certain address or a certain IP address has visited a Facebook page. They can find that information out. Don't do it. The risks far, I mean, if you really are having trouble, invite them in and meet them in person if you're going to do that. I mean, that's the weird part about this, was that there was no in-person interviewing. That's what you should do. And that way you avoid all this stuff, okay? Okay, now let's talk about employee firing. Here are the rules that we know so far. This may change. Next year I may be giving a completely different set of facts here, okay? Here are the general rules. Can you fire someone because of something they say on social media? The answer is yes, if the person disclosed trade secrets or confidential information. The cases so far are unanimous that if an employee breaches their duty of loyalty to the company in some way on social media, even though it's not in a public forum, that is considered a breach of their duty and they can be fired for that. The cases so far are unanimous. If you're working on a secret project for your employer, you cannot talk about that at all online. Okay, that's rule number one. Yes, if the employee commits libel. My boss is having an affair with a coworker, which turns out not to be true. Employees have been fired for that, especially if it's in a public setting. No, if the employee was discussing working conditions or union activity. Believe it or not, there's a section of the National Labor Relations Act of 1947. It's actually called the water cooler statute. It's a statute that says that workers who get around the water cooler and bitch about their working conditions, that is protected speech. And an employer cannot fire an employee because of things that he and his friends are saying around the water cooler. That statute has been applied to social media, and basically saying that if someone's just griping about their conditions, my boss is a slave driver who has me in office every Saturday, I don't like this, that is considered legitimate griping and protected under the National Labor Relations Act, believe it or not. If the conversation is about working conditions or union organizing activity is the other great things. You know, if you go on social media and say, hey, let's form a union, now your employer is really going to hate you for that, but that is protected speech under the National Labor Relations Act. Any kind of activity, and of course, any kind of political speech is absolutely protected. There's a case that just came down last year from Virginia. In Virginia, the sheriffs are elected, okay? And the assistant, some of you know about this case, the assistant, the sheriff for a certain county in Virginia was up for re-election. His number two, frankly, didn't like him. They'd been having a row going for a long time. So he went on the sheriff's opponent's Facebook page and all he did was like the opponent. That's all he did. He didn't say anything about who he was or what his working conditions were. He just liked the sheriff's opponent, and no doubt he voted for him. Well, of course, the sheriff, his boss, won by a landslide, found out about this, and the first thing he did the day after Election Day was he fired his number two, assistant sheriff, who sued, and it went all the way up to the Federal Appeals Court, the Fourth Circuit in Richmond, Virginia, and that court basically said that what he did was political speech, and that was protected under the First Amendment. It was a First Amendment case, actually, which is very interesting because it was a political statement that he was making. He was basically, we all can endorse whatever candidates we want online. That speech is absolutely protected under the First Amendment. So that was a very interesting recent case. I don't remember the name of it, quite frankly, but we know a little bit more than we did when I did this slide about how that kind of speech, but in the area of non-protected speech, different case, okay? The other situation that gets you into trouble here, there is a statute that has been adopted in 36 states so far that say that an employer cannot coerce you into handing over your username or password to a private social media account as a condition of employment. I don't know where Connecticut stands on this, but I know New York has adopted it and 35 other states have as well. And I'm pretty sure if it ever comes into the legislature here, it will almost certainly be adopted. This is the kind of thing we like here. But basically, you should be aware you cannot, for a privately held social media account. So if someone's saying, bad things about their employer on a private Facebook page that's limited only to family and certain friends and that kind of thing, an employer cannot insist on having access to that as a condition of employment. The only exception to that is if there's a suspicion of criminal activity, law enforcement activities. If they have probable cause and they get a warrant, they can force people to hand over that information. But a private employer cannot do that. Right now, the only generalization that I can make here, generally speaking, the courts are giving employers greater rights where the postings are made on a company-owned social media account as opposed to the employee's personal account. So if I'm the employer and I've set up this account, and a part of your job is to update postings on the account and you're saying bad things on there, I have much greater rights than if you're saying things on your private Facebook account. I mean, that's just common sense, but the law so far is backing that up. Or the company provides the employee with the technology or social media account to post online for the convenience of the employer. In 2013, we had a case called the Kwan case. This was out of California. Basically, the town of Ontario, California, if you know, it's near Santa Barbara. It's actually kind of like, where we are here in Southern California, Southern Connecticut, rather. Kind of an upscale, kind of community. Basically decided to give smartphones to all their police officers so that they could communicate more easily with each other in difficult situations and more quickly in times of crisis and whatever, right? So, of course, all the cops got these wonderful smartphones, and what did they start doing in their off hours at the bar after their shifts were over? They started looking at stuff, and what were they looking at, do you think? They're police officers. Take a wild guess what they were looking at. Okay, porn and other related things, right? So the town found out about this, and the police commissioner basically fired these 5 police officers, and they sued, basically saying it was a violation of their civil rights. They were on their off duty. They were not on duty. They were not doing anything in the way to threaten the public or anything like that. And it went all the way to the Supreme Court, and the Supreme Court said no. The town had the right to fire those police officers because they provided them with that technology solely for their use as police officers. They didn't give this to them just for their own private use. This was only meant to be used for the public safety and for the public purpose for which it was done. And the Supreme Court bought that argument. So the cops lost that one. So if you have employees and you don't want them saying nasty things about you on social media, provide them with the tools to do it, is the lesson. That's the lesson so far, really, out of all the cases. Sounds kind of funny, but that is what the law is saying here. Because when you're talking about an employee's private site, and especially a site that's not open to the public, that's when the employer's rights diminish, and they diminish very rapidly. Okay, so what employers should do: develop a social media use policy. There's some standard forms for this. I have them in some of my books, but frankly, most lawyers will have a form that they use, or you can get one offline. There's actually databases of these things, if you look hardly enough on the web, where various companies post their social media policies, and you can see, you can pick and choose the language you want. Host a meeting with employees to review the policy, answer questions, make sure the employees know that there are rules about what they do on social media. That's 90% of the battle. It doesn't really matter so much what your policy says, as long as you hand it to them, and as long as they sign a document that says, I've reviewed this, you have explained it to me, I understand that I have to be careful what I say online. If that's all they do, you're 90% of the way home in terminating them if you feel you have to, because they're doing nasty things online. Okay, so at the very end of the day, so what do you have to think about legally when you post specific content to a social media website? I use what I call the political opponent test. How relevant is this right now as the presidential election is starting to kick off here, okay? Whenever I'm thinking about putting something on my Facebook page or any of my social media pages, I ask myself the question, if I was ever to run for public office and my opponent's attack team got a hold of this, would I be worried? If the answer is yes, I don't post. If the answer is maybe, I don't post. If the answer is yeah, I'm probably okay, I let it sit for a couple of days and look at it again and then ask the question again about seriously, never post anything online that you would want your worst enemy to use against you if that opportunity ever came up. All of us don't like to think that we have enemies. We don't like to think that in life, but most of us do. Trust me, I'm a lawyer. I'm that one. I got a few. Okay, guys. That's it in a nutshell. These are a couple of my books for normal people. None of them really go into this in great detail, although the eBay sellers, I do have a whole chapter there on internet taxes and well, things about sales tax on the internet. So if you know anybody who sells on eBay or Amazon, this is probably the best legal guide for them. The other book that's relevant, though, is a book for lawyers. It's called Advising E-Businesses. But it's not really, it's a nice sort of summary of where the law is today, but it's meant for lawyers. It's not really meant for the general public. So be aware, you're going to be getting into a lot of depth, you know, far beyond what we did in this 1-hour presentation. So that's social media and the law. Thank you very much, guys. You've been a great audience.